In the Idaho 4 case, scheduling is now an issue. Some people want the trial to come up sooner, others later.
Do you have 5 more points for us? The timeline for the Idaho 4 case has been getting longer, but it's still indefinite. I'm Lainey Law.
And I'm attorney Andrew Myers.
Some people want the timeline to slow up. Some people are saying that we need to slow things down. Andrew, what is it that we're here to talk about today?
Well, yes, I do have 5 points, and they all go pretty much to what is going into the scheduling of this case. As you know, Brian Coburger waived his right to a speedy trial. And here we are way more than a year out from not only the crime itself in Idaho, but also the arrest of Brian Coburger. And there are voices out there that are saying, hey, let's go. Let's speed this thing up. One of those voices is a writer in the Daily Mail in early March of 2025. The Daily Mail carried this headline: "In what sadistic world can it take more than 2 years to bring Idaho quadruple murder suspect Brian Coburger to trial?" As a court date moves to 2025, an outraged Maureen Callahan demands answers on behalf of the victims' families.
I think that a lot of people have this expectation that because something horrible happened, that it's going to be dealt with really quickly and right away. And I think that we need to approach things from a more human understanding, where if we're going to do things, we're going to do things right. And right now, as things have been going, there's been a lot of pushback in a lot of different places. So I don't think it makes sense to be trying to speed things up when we've already had so many issues along the way.
Oh, I would agree with you 100%. Maureen Callahan is a society commenter, a social media commenter. She wrote the book on Lady Gaga, and the name of the book, of course, is Poker Face, after one of Lady Gaga's big songs. But so I was wondering why this writer, Maureen Callahan, didn't have more of a poker face about, speeding up the trial. I want to reemphasize and focus more on a point we made kind of quickly in a previous episode, and that is that if Mr. Kohberger's trial is in the summer of 2025, which is what it's looking more and more like at this point, that'll be 2.5 years after his arrest in December of 2022. So keep that number in mind, 2.5 years. That's not so bad, considering that with Laurie Vallow, it was 3 years and 2 months after her arrest on her honeymoon in Hawaii. If the Chad Daybell trial goes as presently scheduled, his trial will have been 3 years and 10 months after his arrest on the same honeymoon in Hawaii. And, nothing is a slam dunk. But as I've pointed out before, the bodies of the 2 kids, JJ and Tylee, were found buried in his backyard. We then go to Hannah Gutierrez. From the date of the crimes until her trial was 2 years and 4 months. And if Alec Baldwin's trial goes as scheduled at this time, his trial will be 2 years and 9 months after the crime, the death of the cinematographer Helena Hutchins. And Adam Montgomery's trial was 4 years and 2 months after the death of the young girl. And as I've said before, you don't subtract the 2 years from which law enforcement didn't even know that the poor girl was dead. And we can say she was dead because the court just recently in New Hampshire said that they'll issue a death certificate, even though they don't have a body. But even from the date that they, started looking and determined that she was missing, it's still 2 years and 2 months. So you know what? 2.5 years from the arrest of Mr. Coburger until his trial, if it's going to go forward, and we don't know, in the summer of 2025, that's not that big of a delay. Now, justice breaks sometimes. 2.5 years, I guess the point here is don't push the court. Don't push them to do a trial, because this is what happens when people are in a hurry. I want to tell the story of 15-year-old Mary Lou Aruda, who lived in Raynham, Massachusetts. And when she was 15, she got on a bicycle one day, went for a ride. She was never seen again. The date that she disappeared was September 8th of 1978. Fairly soon after, they found gentleman by the name of James Cater, and I apologize for using the word gentleman, and he was tried 4 times. Final appeal wasn't until August 30th of 2000. Here is young Mary Lou Aruda, 15 years old, one of the last photographs that was taken after she disappeared on her bicycle, and Mr. Cater, again, had 4 different trials. Here is the court case, Commonwealth versus James Cater. There's the citation if there are any lawyers or others interested in looking at this case. It's 432 Mass 404. And this is the August 30th, 2000 final appeal in this case. And let's check it out. You will see that the actual trials are in yellow on the left. Trial 1 was in 1979 when a jury found him guilty of kidnapping and murder in the first degree. Then the appeals are on the right-hand side in blue, all 7 of them. The first appeal came in, the conviction was overturned because certain testimony had been or might have been hypnotically aided and erroneously admitted. Trial 2, 1986, Cater convicted again. That was reversed on appeal. This was actually the 3rd appeal. The Supreme Court of Massachusetts said we reversed the 2nd conviction because, again, hypnotically aided testimony was erroneously admitted. Way back in the 70s, I guess you had to live through that period to understand that there were people back then that actually thought that hypnosis was an intelligent thing to do because it tapped into the subconscious when people were blocking out certain details, and it would bring up, observations that weren't stored properly in memory. So this isn't the only Massachusetts case that had serious problems due to hypnotically induced testimony. Supreme Judicial Court of Massachusetts said, knock it off. It took twice. And I guess about on the 3rd appeal, the court said, you can use testimony from these witnesses, but only from observations that can be corroborated before they were hypnotized.
Is that still, I need to ask, is that still a thing today with hypnosis? The fact that you can argue that you can't use something because of hypnosis sounds a little crazy.
Well, not in Massachusetts. I don't think any prosecutor or attorney in Massachusetts after this case or the Fells daycare case, and people in Massachusetts will know exactly what I'm talking about. After those 3 cases, actually, because this counts twice, no, I don't think any attorney or prosecutor would even think about the possibility of considering hypnotically induced testimony. I can't speak to other states because I'm only a member of the bar in Massachusetts and New Hampshire. So, all right, they got it on to trial number 3. A 3rd trial commenced in October 1992. And on December 24th of 1992, the trial judge declared a mistrial, and that's because there was a hung jury. And so Mr. Cater moved to dismiss the indictments, arguing that principles of double jeopardy barred another trial. And the court said, nuh-uh, you know what? There was enough evidence that he could have been found guilty. And double jeopardy principles did not bar another retrial because there had been sufficient evidence. It's just because the jury doesn't agree doesn't mean they can't try the case again. So then a controversial thing happened in this case. The Commonwealth filed a motion to admit evidence of the defendant's prior bad acts. Now, Mr. Cater had actually pled guilty and spent, I believe it was 8 years in jail for a similar crime in which a North Andover girl, North Andover being a beautiful town where I had an office for 27 years, Mr. Cater had pled guilty and done 8 years, I believe, in the penitentiary in Massachusetts for picking up a girl off her bicycle, taking her into the woods, and tying her to a tree.
Oh my God.
Only did 8 years and he got out. So, and that girl, well, fortunately or fortunately, she did live. Unlike poor Mary Lou Aruda, that poor girl did live. So the Commonwealth filed a motion to admit evidence of the defendant's prior bad acts. The trial judge allowed the motion, and the defendant sought interlocutory relief. Does that sound familiar, Coburger followers? And a single justice of the Supreme Judicial Court denied the petition on the ground that the interlocutory review was not appropriate. Again, does that sound familiar, Coburger followers? So Mr. Cater was tried for a fourth time on October 31st of 1996. And on December 23rd of 1996, he was found guilty of kidnapping and murder in the first degree. So remember, that's in 1996.
And it doesn't end here.
Appeal number 7. On appeal, the defendant argued just a whole bunch of grounds. We're not going to go over all of them. One of them was that the prosecutor's arguments were highly improper and prejudicial to the defendant. Well, that's an argument. An argument, as long as it's reasonably and rationally related to things that are in evidence, it's okay. And that's basically what the judge said in this appeal. Oh, let's take a look at the number 1 in parentheses at the top. The integrity of the grand jury was so seriously impaired that the indictments should have been dismissed. Does that sound familiar, Coburger followers? And again, without going into all of the facts of this case, because we'll be here all afternoon, it took 22 years. The Supreme Judicial Court of Massachusetts said, no, that's just not going to happen. So that's a case that took 22 years in Massachusetts from the date that poor young Mary Lou Aruda got on a bicycle and disappeared for the rest of her life until the final 7th appeal after 4 trials. And that's the long, sad story. It's something that's always bugged me because it kind of transcends both of my careers. I was a reporter, and I remember this happening. And then I went to law school and got out of law school, and they were still working on this case. So I remember when Jay Logston got up in the hearing in January of 2024 and said this case could take, I think he said, 28 years. Well, here's one that took 22 years. So just horrible and devastating.
Yeah, I think a lot of people are scared of a situation like this, where someone's convicted and then it gets undone and then you're stuck here for 20 years. But I think that it's important that things be done right the first time, which unfortunately we're not seeing, to avoid situations like this. But, here's hoping that we don't find ourselves talking about this in 20 years.
No. It's just unthinkable. And again, there's the case citation if anybody wants to double check that. And then we hear people talking about closure. The parents need closure. Here is what Mary Lou Aruda's mother said after that final appeal in 2002, 22 years after the murder. She said, and I quote, "It doesn't get any easier. You just learn to live with the pain. There is no closure. There's just knowing the defendant is behind bars forever." And that's a good quote. Not only was it in all the newspapers, but I know the reporter that documented that quote. So that, no closure. Mr. Cater died of cancer in the penitentiary in Massachusetts in 2016. So, if you're looking to the courts for closure, you might think about, looking inward or looking to your faith or looking to whatever it is that is within you.
I think a lot of people that have lost a loved one, hopefully not in circumstances as grim as this, can empathize with the fact that especially if something happens unexpectedly, years pass and you're still thinking of that person, you're still wishing you could just talk to that person. I think adding the extra layer of needing to dedicate so much of your life, hoping that there's going to be a resolution and hoping that this doesn't happen to other people, it's an unimaginable suffering. And unfortunately, just getting the final verdict, although it's relieving to know that someone is rightfully behind bars. At the same time, it doesn't lessen that pain that you experienced from the whole event in the first place that shouldn't have even happened.
No, I know you're right. And on a personal level, I lost my brother when I was 15, and he had not even been out of high school for a year when he died in Vietnam, in the war in Vietnam, and came back in a plastic bag. And, it's something that always stayed with my parents. It just always, always, always stayed with my parents that my brother died at the age of 18 in Vietnam, and I'll stay away from the politics. I'm going to talk about, how it affects parents. My parents never got over it. Sure, they went on with their lives and did what they needed to do. But, when my mother died at the age of 93 on her deathbed, she was still thinking about him, and she said, I'm going to go see him. So I never liked the word closure. I never liked that word because I don't know what it means. Mary Lou Arruda's mother was quoted as saying there is no closure. I mean, sure, the court was done with what it needed to do, but it took it 22 years. We see that the parents, from what we see on various documentaries on television, they've been devastated. And, some of them have their faith, and they've talked about that. I just wonder, hopefully the Coburger case, it's going to take time to get there. I don't think anybody needs to push them or write articles in the newspaper like we saw here. What's wrong with the society? Because it takes time to do it right. I want justice as much as anyone else. I don't know what happened. I really don't. There's so much secrecy and redaction and everything else. I don't know what happened, but I do hope that there's justice. I guess the point I'm trying to make is that there is no closure.
Yeah, a lot of people think that, for example, once this case is over, if Coburger is convicted guilty, like we always say, and he's presumed innocent until proven guilty. But regardless of what the result is of this, it's not like someone's going to press a button and then everything's going to be better. Idaho is still going to be left with this empty hole where we used to have 4 people that were dearly loved. And obviously we want things to progress through the system, but at the end of the day, it's not like a magic switch that's going to fix anything.
Nope. Well put. So the final subject we're going to talk about today, and we've talked about this before, was there an accomplice? Interestingly, Dr. Catherine Ramsland, who we all know was one of Brian Kohberger's teachers at DeSales University in Pennsylvania when he was studying at that school, she's written a new book, and it's not out yet. And I didn't receive an advance copy to do a review like so many other people have, because I've been able to read a couple of reviews, but the book is due out in about a month from the date that we're recording this podcast. And interestingly, the book is about serial criminal guy Dean Corll, who in the 1970s was favoring young boys in his murders. And he actually retained a couple of young boys. One of them was 14. And this book kind of centers, from the reviews I have been able to read, centers around that young boy's experiences. This man, Mr. Corll, had found him. And he realized that maybe this boy was worth more than just, doing what he did with these boys. And he retained him as an apprentice. And he would pay this young boy, and another one actually, $200 each time they could bring him another young boy to be his victim. And so, everybody went to jail, fortunately. But the book is entitled The Serial Killer Apprentice. So I saw this and I scratched my head and I said, Now, this happened in the 70s, and Mr. Coburger went to DeSales University, and this had to be in Catherine Ramsland's mind. I know that some of my professors, college and law school, would talk about projects that they were working on, and after we graduated, we saw them. So I just wonder if this is something that came up in classroom and out of classroom activities, and that Brian Coburger had on his mind. And so I'm just wondering if he was an apprentice, if he was the mentor, or neither. I'm just wondering, and I don't know. It's only a question. Was this something that was on his mind, that, you could get an apprentice to help you? Because a lot of people including us in a previous episode when we asked, we had 18 reasons why it wasn't just one person. And we had a really good person helping us, Forensic Frenzy. And we looked at the fact that we don't believe that it was just one person. Well, all right. This is all speculation. I know you tell me that down in the comments, but you know what? I just wonder if she was writing this book or, thinking about it when he was there. And, was he the apprentice, the mentor, or neither? Who was teaching whom and what? I don't know.
The idea, I mean, I mentioned this quite frequently. I feel that I can't even begin to understand how people get to the point where they are committing crimes like this. But it's beyond that insane to me that these people are able to get other people, and in that case, financial benefit, but even in some cases without any financial benefit, to be able to get a team of people to cooperate and do this stuff. It's frankly bizarre and interesting that we have these cases to see, but obviously they're horrible situations. It makes me wonder what goes wrong in people that they get to that point, but then also what about them is even able to convince other people to join them on that? Because if someone came up to you asking for help in that regard, you wouldn't. But how are these people even able to charm people to work for them in that regard is insane to me.
Well, that's why you need a forensic psychologist like Dr. Ramsland, because, books like this, do the best that they can, informing you, what motivates people. I remember reading some of Ann Rule's books, and she would talk about the upbringing and the formative years of people like Ted Bundy, who she knew personally, but not just him, some of the others. And she would talk about the factors that go into the upbringing of these people. Some of it is believed at this point now to be organic, genetic. Some of it is believed to be environmental. I don't think there's a clear, sure, if you talk to the forensic psychologist, sure, one will say one thing and the other will say the other. And that's why I say I don't think there's any universal agreement as to what motivates someone to engage in the type of true crime acts that we've heard about, both from this new book that she's written or by whoever committed the Idaho 4. And I'll contend that we don't really know. They've established probable cause through a series of circumstances, which I would contend are very controversial, but it's an issue. We just don't know. And I guess the final issue that we're not going to get into today is, what's going to be on the minds of the jurors. There's just been so much publicity. There's just been so much attention. The probable cause affidavit has been torn to shreds by people who looked at it, analyzed it, thought about it, and said, geez, not only was there an 8-hour delay, but there are there's got to be 30 or 36 issues that are raised in that 8-hour delay. So the touchstone of how you get a fair jury isn't what information they have, but whether, despite that information, they can be fair and imbalanced. How do you do that? And what are people thinking? Do our viewers represent potential jurors? I really don't like teases, but that's for the next episode of this podcast. Any closing thoughts, Lainey?
Thank you. As always, thank you guys so much for watching. I hope you guys, despite the grim topics of our video, sometimes I hope you guys enjoyed the video, and we look forward to seeing you guys in the next one.
Thanks a lot. We do appreciate comments. In our next episode, we're going to read. We had asked our viewers to tell us what their top 5 issues. We've done a lot of these episodes where we talk about, 5 issues, 10 questions, 4 yellow flags. And so we asked our viewers to tell us what your top 5 issues are, and you did. And so that's for our next episode. I always ask people to please be sure to comment, but be nice, be polite, be respectful, no matter where you are, not just here. If you're in the grocery store, the shopping center, the big box store, the gas station, no matter where you are, please be polite and respectful. We don't mind comments that are contrary to what we say, but if you personalize it and say, you're an attorney, you, blah, 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 guess what? We have a little delete button right here, and we don't mind using it. So thank you very much for being with us, and we hope you have a great day. You have been watching About the Law, a production of the law offices of Andrew D. Myers in Methuen in the Merrimack Valley of Massachusetts and in Derry, just outside of Manchester, New Hampshire. Remember to click the like and subscribe buttons down below. And if you enjoyed this video, be sure to share it with your friends and others. If you'd like to talk to me about an injury case, a car accident, a slip and fall, a serious bodily injury case, or some other case, please feel free to contact me. I'd love to talk to you. You can contact us through my website at attorney-myers.com. We have a contact us block, or you can call on one of the telephone numbers we've given there, or you can email me at andrew@attorney-myers.com. The foregoing is offered for informational purposes only. It is not intended as and does not constitute legal advice. Laws vary widely from state to state. You should rely only on the advice given to you during a personal consultation by a local attorney thoroughly familiar with state laws and the area of practice in which your concern lies. This podcast must be and hereby is labeled advertisement in some jurisdictions.
And that's that.
And that's that. We didn't have any tunnels today. We didn't talk about tunnels today.
No tunnels, no horses, no emails, no phone calls.
No tunnels.
No tunnels.
There are tunnels.
No
There are
tunnels.
tunnels. They're just not there.
No
There
tunnels.
are tunnels. They're just not there.
Mm-mm.
Oh, there's tons of tunnels.
No tunnels.
There's tunnels everywhere.
Mm-mm.
There's a tunnel under this office.
About to go find it.
No, 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 no way.